Imagine this. Alemu agrees to sell his house in Addis Ababa to Tigist for 2 million birr. They shake hands in front of a witness, and Tigist hands over a substantial deposit. A week later, Alemu changes his mind and refuses to transfer the property. Can Tigist force him to honor the deal? Under Ethiopian law, the surprising answer is no, and today we will discover why. Let us begin with the exact words of the law. Article 1723 of the Ethiopian Civil Code, titled Contracts Relating to Immovables, reads as follows. Subarticle 1. A contract creating or assigning rights in ownership or bare ownership on an immovable or an usufruct, servitude or mortgage of an immovable shall be in writing and registered with a court or notary. Subarticle 2. Any contract by which an immovable is divided and any compromise relating to an immovable shall be in writing and registered with a court or notary. Working alongside this provision, Article 1720, Subarticle 1 tells us, where a special form is prescribed by law and not observed, there shall be no contract but a mere draft of a contract. Now, let us unpack what this means, element by element. First, we must understand what immovable property is. In legal terminology, immovable property refers to land and anything permanently attached to it, buildings, houses, fixed structures, and the like. Unlike movable property, such as a car, furniture, or livestock, immovable property cannot be physically relocated. The legal interests attached to immovables tend to be long-lasting and socially significant. Because of this significance, the Ethiopian Civil Code subjects contracts relating to immovables to a higher level of formal scrutiny than ordinary contracts. When Ethiopians buy a house, divide inherited land, or grant a mortgage on their property, they cannot simply shake hands and call it a deal. Second, Article 1723 imposes not one but two cumulative requirements. The contract must be reduced to writing, and that written document must be registered with a court or a notary. Both requirements must be satisfied simultaneously. A written contract that has not been registered or an oral agreement later acknowledged before a notary without a proper written instrument would each fall short of the standard Article 1723 demands. This two-pronged requirement ensures both evidentiary certainty and public notice of property transactions. Third, we must know which transactions fall within the article's reach. Subarticle 1 identifies four categories. The first is ownership, or bare ownership. Any agreement that transfers or creates full ownership rights in land or a building, most commonly the sale of a house or a plot of land. The second is usufruct, the right to use and enjoy another person's property and collect its fruits, such as rental income or crops, for a defined period without owning the property outright. The third is servitude, a right that one parcel of land enjoys over a neighboring parcel, for example, a right-of-way allowing one landowner to cross another's property to reach a public road. The fourth is mortgage, a security interest in immovable property, typically created to secure a loan. Because a mortgage can lead to the forced sale of a person's home or land if the debt is unpaid, the law insists on written and registered documentation. Subarticle 2 adds two more categories. First, the division of an immovable. When co-owners decide to partition jointly held land or a building among themselves, Article 1723 applies. Think of a family dividing an inherited parcel of farmland. The agreement to divide must be written and registered. Second, a compromise relating to an immovable. A compromise in contract law refers to a negotiated settlement of a dispute. When parties reach an out-of-court settlement over a disagreement about immovable property, for example, settling a boundary dispute, that compromise agreement must also be in writing and registered. Fourth, and perhaps most critical, we must understand what happens when these formal requirements are not observed. The answer lies in Article 1720, Subarticle 1. The transaction does not become a voidable contract that one party can choose to enforce or set aside. It is not a contract at all. It is merely a draft, meaning the parties have no binding obligations toward each other on the strength of that document. No court can enforce an unregistered oral agreement for the sale of land regardless of how clear the parties' intentions were or how much money may have changed hands informally. Fifth, two related provisions work in tandem with Article 1723. Article 1721 governs preliminary contracts, sometimes called agreements to agree or pre-contracts. A preliminary contract must be made in the same form required for the final contract. This means that even a promise to sell land must itself be in writing and registered. Parties cannot bypass Article 1723 by characterizing their agreement as merely preliminary. Article 1722 governs variations. Once a contract has been made in a special form, any subsequent modification must also be made in the same form. A written and registered contract for the sale of land cannot be varied by a later oral side agreement. If the price changes, the delivery date shifts, or any other term is amended, the variation must itself be in writing and registered. Sixth, Articles 1727 and 1728 specify what written form actually demands in practice. The contract must be supported by a special document signed by all parties bound by the contract. The document shall be of no effect unless it is attested by two witnesses. A party must affix their handwritten signature or, where a party cannot write, their thumb mark. These requirements ensure that the written document reflects genuine, considered consent rather than a hastily prepared or forged instrument. Finally, we should understand the role of notaries and courts in registration. In Ethiopia, notaries are public officials authorized to authenticate documents. Registration serves a dual function. It provides evidence of the transaction, and through public registration, it gives notice to third parties, such as future buyers or creditors, about existing rights over the property. This protects innocent third parties who might otherwise be unaware of prior transactions. Now let us see how these rules play out in concrete scenarios. Return to our opening example. Alimu agrees to sell his house to Tigist for 2 million birr. They have only a witness to confirm the oral agreement, and they delay drafting any written document. Under Article 1723, Subarticle 1, this transaction has no legal existence as a contract. If Alimu refuses to hand over the property, Tigist cannot sue for specific performance because no contract exists in law. Even if Tigist paid the full price, her remedy would not be contractual enforcement of the sale, but would lie elsewhere, such as restitution for unjust enrichment. The lesson: always reduce a land sale to a written, registered document before handing over any money. Consider a second example. Bekele wants a bank loan to expand his business and offers his commercial building as collateral. The bank agrees verbally, and Bekele signs a single page of acknowledgement, but no registered mortgage deed is prepared. Later, Bekele defaults. The bank would face serious difficulties enforcing the mortgage because Article 1723, Subarticle 1, requires that a mortgage of an immovable be in writing and registered. Without registration, the bank does not have a valid mortgage and cannot assert a preferential claim over the building in insolvency proceedings or foreclosure. Banks must therefore insist on formal compliance before disbursing loans secured by immovable property. A third example involves family land division. 3 siblings, Sarah, Dawit, and Moran, inherit their late father's farmland. After negotiation, they agree verbally on how to divide the land, and each takes possession of an allocated portion. Under Article 1723, Subarticle 2, this division has no legal standing as a contract. Should a dispute later arise about boundaries or ownership, no court will enforce the verbal division. The absence of a written and registered division agreement could force the siblings into lengthy litigation. Families dividing inherited land must work through a notary or court to formalize the division. A fourth example involves compromise. 2 neighbors, Hiwat and Lemma, dispute where the boundary between their plots lies. They reach a compromise and shake hands, agreeing that the boundary will run along a certain line. Neither bothers to put the agreement in writing. Article 1723, Subarticle 2 provides that any compromise relating to an immovable must be in writing and registered. Their handshake deal is unenforceable. If Lemma later disregards the agreed line, Hiwot cannot rely on the compromise as a binding contract. Now, some exam tips. Remember that Article 1723 mandates two requirements. The contract must be in writing and registered with a court or notary. Both requirements must be met simultaneously. The covered transactions are broad: creation or transfer of ownership, bare ownership, usufruct servitude, and mortgage over immovables, as well as division of immovables and compromise agreements relating to immovables. Noncompliance is fatal. Under Article 1720, Subarticle 1, the agreement is not voidable, it simply does not exist as a contract. Preliminary contracts and variations must observe the same formality. Practice applying these rules to fact patterns involving house sales, mortgages, family land divisions, and boundary disputes. Thank you so much for watching. Whether you are an LLB student preparing for exams or a member of the public curious about the laws that shape life in Ethiopia, we are glad you joined us. Please subscribe and stay with us for more clear, practical explanations of Ethiopian law.